12. Criminal law. Individual members of the family sometimes indulge in behavior that is in conflict with the rules of living which well-ordered society prescribes, and through failure to conform to these standards they come in contact with the rigid regulations of the criminal law. This type of behavior is very costly and destructive in its effect, both upon the individual and upon society. Scientific studies and research programs have shown that the causes of criminal behavior are as varied as the individuals concerned, for mental and social unintelligence, hereditary instability, economic dependence, and unwholesome environmental factors, including broken homes, all have their place in the evaluation. It is only through a knowledge of the individual's physical, mental, and emotional makeup and the reaction to environment and the pressure of life that the results, namely the behavior, can be understood. This is the function of the social forces in the community and not in a strict sense of the criminal law. Through child welfare agencies, character-building agencies, church organizations, and school departments we have proof of the psychological truism that habits, either good or bad, formed in childhood are carried over and become a part of adult life. It is evident that the social aspects of the problems of human behavior are allied with preventive measures and that prevention should begin in childhood. Many individuals can be kept from careers of crime by proper training and treatment in their early years. The act and the individual. From a legal viewpoint, criminal law, as one branch of the whole field of law, deals with crimes and punishment, and it has seemed more concerned with the act than with the individual or with the causes which contribute to criminal behavior. It is exact in its definitions and uniform in the punishments which are imposed through the courts. For this reason, medicine, psychiatry, and social work have not had the recognition by the courts which these sciences should have received, except in the juvenile court where the services have been used and their value understood. What is a crime? A crime is a wrongful act, but an act may be wrongful and still not be a crime. For instance, it is ethically wrong to lie about a neighbor, but this is not a crime in the legal sense. According to Blackstone, a crime is an act committed or omitted in violation of the public law, either forbidding or commanding it. It is therefore an act which is recognized as being against the welfare of society and is so serious that the state will take action and see that the offender is punished. The acts which are crimes are determined by the statutes of the various states, which have modified and added to the English common law of crimes as it existed when this country was settled. Because the statutes are not uniform, an act which is a crime in one state may not be so in another. Also, an act that was considered a crime in one period of progress may not be considered so at another time. Likewise, the punishment for certain crimes has changed. The ducking stool and the pillory were used in England, but the Quakers very early frowned upon these modes of punishment, and they never became a part of the law in Pennsylvania. A wrongful act may be a tort as well as a crime and so give rise to two rights of action, one civil and the other criminal. As an example, if a man quarrels with another man and knocks him down, this is a crime which is against the peace and security of the public, and the state will prosecute for assault and battery, but the injured person has a right to bring an action for damages. Also, as both actions can be maintained, bringing one does not bar the other. There are many other instances where dual rights exist, as in larceny, robbery, or failure of duty amounting to negligence, which are all crimes but cause damage and loss to the individual as well. 3 classes of crimes. Treason. Crimes are classified as treasons, felonies, and misdemeanors. At common law, high treason consisted of causing the death of the sovereign, levying war, or certain other acts against the sovereign. Petty treason at common law arose when a superior was killed by an inferior, as for instance a husband by his wife or a master by his servant. The act that was petty treason at common law is a felony in this country and may be murder or manslaughter, according to the circumstances. The Constitution states treason against the United States consists only in levying war against them, or in adhering to their enemies, giving them aid and comfort. There may also be treason against the individual state, and in either case it is considered the greatest of all crimes because it seeks to undermine the very existence of the government and to overthrow it or betray it to the enemy. Felony. A felony at common law included all the other crimes except treason, which were punishable by the forfeiture of property, and usually by death also. In this country, a felony is usually held to be any offense which may be punished by death or confinement in a state prison, and because of our more complex mode of living made a social, industrial, and commercial offenses are included that were unknown at common law. There are now only a few crimes which carry the death penalty. Misdemeanor. Misdemeanors include all crimes which are less than felonies and are punishable by a fine or jail sentence. Types of crimes. A further classification of crimes divides them into crimes against the state or public administration, and those against the public peace, crimes against public morals, such as seduction and various sex crimes, those against the person, including murder, manslaughter, assault and battery, and kidnapping, and, finally, those against real or personal property. The elements of a crime. Every crime consists of two elements, the criminal act or omission and the intent. The intent is presumed from the act when any person, except one whose mind is not capable of entertaining intent, commits an act which is prohibited by law. The act and intent must both exist, and mere intent to do an act which would be a crime is not a crime, though it may be an attempt. If a man walks along the street intending to pick another's pocket and actually puts his hand in the other man's pocket but takes nothing because there is nothing in the pocket, that is not larceny but an attempt at larceny. Likewise, if a man intends to take a coat belonging to another and actually takes the coat and then finds it is his own coat, there is no larceny. The intent must not be confused with the motive, for the latter is the reason for doing the act while the intent is the determination to do it. The motive may be good, but if the act is prohibited by law, it is a crime, as for example the practice of polygamy on the grounds of religious belief. A man was indicted for bigamy and said he was a Mormon, and that as a part of his religious belief he could marry as many women as he could support. This was held to be no excuse. It is an established rule of criminal law that everyone is liable not only for an act which he actually intends and commits, but for all the natural and direct consequences of the act. So if a man enters a house intending to commit a burglary, and while there kills the owner of the home, he is guilty of the latter crime, for it is presumed that he intends the consequences resulting from his act. These were the exact facts in a New Hampshire case, and when the man was killed it was held to be murder in the first degree. Though not committed with a deliberate and premeditated design to kill, this is called constructive intent. The mental elements which constitute criminal intent differ in the various crimes and are expressed by specific words in some instances. For example, in murder it is necessary to have malice aforethought. In larceny there must be a felonious taking and carrying away of the goods of another. And in embezzlement, which was not an offense at common law, the intent to defraud is a necessary element. No person can be guilty of a crime unless he has sufficient mental capacity to entertain the necessary intent, and the law makes certain exceptions with this in mind. At common law, a child under 7 was presumed incapable of entertaining criminal intent. Between 7 and 14, the usual presumption was that the infant lacked discretion or criminal capacity, but over 14 he was presumed to have sufficient capacity, and this had to be met by counter-proof. A person so insane that he is incapable of distinguishing right from wrong is unable to have criminal intent, and is hence incapable of committing a crime. No person can be tried, sentenced, or punished for a crime while insane. Some courts recognize a resistible impulse as a good defense, and if the act is the result of such an impulse, there is no responsibility. But on this point, one court has said that not every slight aberration or derangement will excuse violation of the law, for there is criminal responsibility if there is mental capacity sufficient to fully comprehend the nature and consequences of the act. If a man is so drunk that he does not know what he was doing, he may be incapable of entertaining the intent necessary, though usually it is held that voluntary intoxication is no excuse for the commission of the act. It is admissible as evidence to determine the degree of the crime in some instances, and proof of it may reduce murder to manslaughter. Acts legal if committed by an officer. An act which would be a crime if committed by an ordinary individual is excused if committed by an officer in the performance of his duty. Hence, when an officer shoots to prevent a prisoner from escaping and the person is killed by the shot, this is not homicide. At common law, this privilege of shooting to prevent the escape of a prisoner extended to anyone who saw a felony committed. But at the present time, no one but an officer of the law is justified in killing another to prevent a felony. It is recognized, however, that anyone may go this far in self-defensive. Without fault on his part, he is attacked by another who indicates that he intends to kill and gives reason to believe that he will be able to carry out this intent. Along with this goes the very old rule that one must retreat to the wall if by so doing he can avoid the actual use of force. In a certain case, a son shot his father with a gun. causing such a serious wound that he died shortly afterward. The evidence showed that the father had become very angry with his son and at the time the shot was fired was pursuing him with a pitchfork. The jury had to decide whether on the facts they might conclude that the father intended to take the life of his son, or, on the other hand, they might believe that the son could have protected himself by retreating. The rule followed was that when it is possible to retreat, one is not justified in taking the life of another. 6. Defense of one's family stands on the same footing before the law as self-defense, but one can use only reasonable force to defend property, and this must not endanger life. Certain acts of defense are allowed, however, if one is attacked and retreats to one's home, for then he need not retreat farther than the threshold. Ignorance or mistake concerning the facts may be a good defense to a crime. So if a person acts on a bona fide but untrue belief as to the facts, he is held responsible only for the act which he thought he was committing. In an Old English case, a man killed another, thinking he was killing a burglar in his house when actually it was his servant whom he killed. This was called neither murder nor manslaughter but misadventure. However, ignorance of the law is no defense. It is said that this is a rule of necessity, for if one could allege ignorance of the law to excuse a criminal act, it would never be possible to convict anyone. Parties to a crime. The parties who participate in any crime which is serious enough to be a felony are principals and accessories. At common law, this classification was according to the nearness or remoteness of their connection with the crime. The principal actually commits the crime, and at common law, and in some states there is a distinction between principal in the first and second degree, the latter being one who does not actually commit the crime but who is present at the time and gives aid and encouragement. In misdemeanors, all are principals. Accessories assist in a variety of ways, which may be either before or after the crime. The accessory before the fact is one who is not present at the actual commission of the crime but procures or advises another to commit it, while the accessory after the fact receives, comforts, or assists the principal to avoid punishment by helping him to escape, by concealing him, or by suppressing testimony against him. At common law, the wife's duty to aid and succor her husband prevented her from being an accessory after the fact. Jurisdiction of the crime. Jurisdiction includes the power to hear the facts and determine the crime. The place where the crime takes effect is the locality of the crime, and so if a man stands in one state and intentionally fires a gun at another person across the line in an adjoining state and injures him, it has been held that the state which is the domicile of the injured party has jurisdiction for punishing the offender. 6. Contrary to this rule, one court has held that when cattle were stolen in one county and brought into another county, the offender could be tried for larceny in the county into which the stolen property was taken. 7. This is on the theory that it is a continuing crime and there is a new taking and larceny in every jurisdiction into which the property is brought. As a rule, the jurisdiction of a county extends only to its boundaries unless it is bounded by the high seas, in which case the government has a quasi-territorial jurisdiction for 3 miles out to sea. Extradition process. If the guilty person escapes into another state after committing a crime, he is a fugitive from justice. He cannot be punished where he is found, for he has committed no crime there, and an officer from the state in which he has committed the crime cannot go into another state to arrest him. The only way that he can be brought back to the state from which he fled is by the process of extradition, which can rightly be considered as part of criminal law procedure. The Constitution provides that any state of refuge shall surrender a fugitive from another state, and the procedure is by application to the governor of the state of refuge by the governor of the demanding state. This is accompanied by a copy of the indictment found, or complaint made to a magistrate, in the demanding state and certified by the governor as authentic. If the governor of the state of refuge is convinced that the accused is a fugitive from justice, he issues a warrant to the agent of the demanding state, who arrests and removes the prisoner. Extradition cannot be denied on the ground that the act which has been committed is not a crime in the state of refuge if it is a crime in the demanding state. And while the governor cannot be compelled to issue a warrant, he is expected to do so, for the judicial proceedings of one state have full faith and credit in every other state,